Hello, everybody. I'm Mike Dowdy. I'm the Assistant Superintendent for the Northeastern Regional Information Center, and I'm here with Monica. Would you like to introduce yourself?
Hello, I'm Monica Statiel. I'm the manager of data security and privacy at NERIC.
And we're also joined by Michelle Jones. Michelle?
Hello, my name is Michelle Jones, and I'm General Counsel for Capital Region BOCES.
And Lorraine Hohenforst from HFM BOCES is with us. If you'd like to introduce yourself and the folks that you have with you.
Sure. Good afternoon. I'm Lorraine Hohenforst. I'm the Deputy Superintendent at Hamilton, Fulton, Montgomery, BOCES. I have with me Elliot Thomas, who is our Director of Technology, and Michelle Husick, who is my administrative aide out of the Deputy Superintendent's office. So thank them both for being here, Elliot and Michelle. Thank you.
Great. Thank you, Lorraine. So we're here to talk very specifically today about third-party contracts. And there's a ton of detail here that we want to make sure that folks understand. We'll be sharing with you our perspectives on this and some tools that you can use. But it's really important to know that the purpose of this presentation is not to turn you into a contract attorney. And to say that you would be able to review a contract as an attorney would after this would be like saying that after taking a CPR class, you are a cardiologist. So that is not going to be the case today. But at the same time, we hope to give you a deeper understanding of all of the components that have to be incorporated into third-party contracts in order for them to be EdLaw 2D compliant. So Monica?
All right, let's get started. All right, so we're going to work this presentation today off of the RIC 1, Part 121 of the Commissioner's Regulations implementing EdLaw 2D Toolkit. It's a big mouthful there. But if you've been to any of the previous trainings, you know that this is the book that we basically work out of. We have our textbook and we have our workbook. So we will be looking at the workbook today, pages 6, 7, and 8. So as you review this, this video later on and you scroll back to catch things, it's a good idea to print out this workbook, and you can find it at the RIC 1 DPSS website resources page. So that's where I will be referring to all of this information. So there's 4 things that you have to have done related to getting your third-party contracts done. And Mike, do you want to take the first one?
Sure. Basically, in each of these 4 things, there's overlap among the 4 of them, and that's really important to understand at the beginning of this, because it's going to feel redundant at times because different parts of the law overlap in terms of what's required. The data confidentiality and maintenance, this is basically saying that the vendor has to agree to comply with EdLaw 2D, and it has to agree to comply with local policy. So that would be board policy in this case. That's all that is. That's very simple. That it's saying the contract has to comply.
But on page 6, the first 2 sections, it's not very simple. Those 2 confidentiality requirements. So thank you for clarifying what it actually means. All right, and then we have the data security and privacy plan. Now we know that we as districts have to have a data security and privacy plan in place, but EdLaw 2D states that vendors also need to have a data security and privacy plan that aligns with a district's data security and privacy plan. And that's one of the things that you're going to be checking for. And there's a whole list of things, and we'll go through them as we go about what each one of them means.
The supplemental information is another piece that's required under the law and regulations. That is some very specific information that the vendor has to provide to the district or to the BOCES that's holding the contract. We'll go through each one of those in turn as well.
And then, now that's going to be page 7, Mike, so that's 7. Page 8 is additional statutory and regulatory obligations. And by the time we get there, we'll be ready to hang up. There's a lot of duplication when we get to page 8, but that's really everything in a nutshell, just to cross your T's and dot your I's. Those are good best practices for contract. Would you agree to that, Michelle?
Yes, actually, I would. And so as we go through this, this is the process we use at Capital Region BOCES. Be happy to answer any questions from that perspective, from our practice at Cap Region BOCES.
Okay.
I'll say it for Michelle. So Michelle is our general counsel at Capital Region BOCES. So everything she says on here is really for informational purposes only. It's not to be considered legal advice. And one thing that you will hear over and over again in this presentation, to the point where it might really annoy you, is that oftentimes the answers to questions are consult your local attorney. Michelle, anything to add to that?
No, Mike, I think you covered it, but thank you so much for bringing that forward.
All right, so before we actually get into looking at the contract, there's a lot of things that have to happen before. And we're not going to talk about a whole, how do you do it at your district? Like, what is the process of procurement? We're going to talk about that at a later date. But there is something that you need to take into consideration after you have a process put into place on what teachers or other staff should do if they're looking for software and they come to you. And at that point, this is a great workflow that I believe Mike and Michelle worked on together. Mike, do you want to go through this?
Sure, really quickly. It's basically, the point is that you need to have some sort of process in your organization, whether it's a BOCES or a district, for how you procure and approve software for use. So basically, if you start with those two black rectangles up at the top, let's say some piece of software is identified by a teacher or an administrator, and then the question has to be asked, is there a legitimate purpose for us to use this instructionally or for management purposes in the district? So if it is, okay, you proceed in the process. Then at that point, you need to determine whether or not the software is compliant with Ed Law 2D and Part 121 of the regulations. So at that point, it could go one of two ways. If the BOCES holds a contract, so if you contract with a BOCES or a RIC for it, thank you, Monica, for pointing to that, in the navy blue rectangle over on the right, that really streamlines your process, because if the BOCES or the RIC enters into the contract, they are either likely holding an Ed Law 2D compliant agreement or are in the process of negotiating one. And if that's the case, then you're all set. You'll be able to use the software, and then the required elements will need to be posted. And those are the ones that are in the supplemental information, which we'll talk about later, that have to be published on a website in a publicly facing way. So that's one way to do it. That's the streamlined way, and you can tell by the diagram. So then if you go back up to the teal rectangle up there in the upper left, let's say the BOCES, you want a piece of software for which the BOCES does not hold a contract. Okay, so then you have to decide if you want to try to negotiate an individual contract with a vendor. And that can go one of two ways. If it's something that you would pay for, generally or likely, you'll have to have some sort of signed written contract. That's the rectangle on the left. And if you have a signed written contract, you have to evaluate the contract for compliance with Ed Law 2D, which is what we're going to talk about today. And then you'd be able to approve it and then put the required elements up on the internet. The other way is if there's some sort of click wrap agreement. And that would be where maybe it's something free that you don't necessarily have a written contract, but you click to accept the terms. And then you need to figure out a way to determine whether or not that agreement then complies with the law. So, and if it does, then you're able to move through the process, approve it, and post the required elements. Michelle, anything to add on that?
No, I think you covered it. I think that the goal is to make sure that every application, every contract that stores student PII or APPR information should be compliant with the law. And so this analysis is critical every time you start looking at an application or a vendor.
So Lorraine, you had a good question. You want to ask that question?
Yeah, so this is really important, and I think some of our districts are confused, and I want to make sure we're providing the right information. So there are software programs that have been deemed EdLaw 2D compliant by certain other BOCES, right? So there are consortiums that have said, you know, what about this software? And they've gone through this whole process. If it's on that list, I think some of our districts are thinking that they could just then use that software. But I think what I would like very clear statement for them is I believe they need to purchase that software through the BOCES that has that agreement on the consortium list. So I see nodding, so I'm going to mute and perhaps somebody could speak perhaps more fluently or specifically to that issue.
Yep, I'll start, and then Michelle, if I miss anything, it'd be great if you chimed in. So the answer to your
Will do.
question is yes. A district will need to purchase it through the BOCES or the RIC that holds the contract. Just because there is a contract with a BOCES does not mean that those terms and conditions apply to every district in every BOCES. That is the current and generally accepted interpretation of the law, that the contracting agency is the one that holds the compliant agreement. So in order to have access to that agreement, you need to buy it through the entity that holds the agreement with the vendor. Michelle?
I agree with that. And this is where the first time we'll say this is where reasonable minds differ. And so there's some question at the state level as to whether or not districts or BOCES can opt in to be covered by a data security and confidentiality agreement anywhere, no matter how you procure the vendor software. And I disagree with that. And so this is the conservative advice that I'm giving to my BOCES, that you do actually have to purchase or be part of the COSER, either purchase the vendor software through the BOCES with the data security and confidentiality agreement, or be part of the COSER with the BOCES that has the data security and confidentiality agreement.
And that also extends to the statewide consortiums out of Erie One and OCM BOCES. So anything purchased through those entities also would be covered under Erie One's and OCM's agreements with individual vendors.
Correct.
Okay, Monica, let's press on.
Okay, so Preston, I just want to mention on this, well, we'll talk about it later. We'll move on. Okay, we are on page 6, the data of the third-party contracts checklist. And this one is going to talk about and focus on the data security and privacy plan, which is 121.6. We'll go through each one of these elements of page 6, starting with security protections. So security protections, it says, does the plan specify the administrative, operational, technical safeguards? I'm not going to read all of these checklists or we would be here for hours, but I thought it would be a good idea if we saw what it was on the checklist, and then I was lucky enough to get my hands on a good example of what a data privacy data share agreement. I'm trying to think of the correct term for this, Michelle. A data share agreement that has been in use, and I was able to extrapolate the information that applies to security protections. So throughout the rest of the presentation, you're going to see what the checklist question is, which is pretty long, and we're going to try to interpret that out a little bit. And then we have an example of what a contract looks like that fits this checklist. So the first one that we're talking about is security protections. And this is basically—
Monica, sorry to interrupt. And in the interest of full disclosure, this agreement from which Monica has deftly excerpted language to match up with the different parts of the checklist, this is an agreement that Michelle negotiated on behalf of Cap Region BOCES with Cisco for us to procure WebEx. So that's where this information is coming from.
Yes, and there's many more pages than what I've put on this presentation, so I want to make sure that I'm clear about that too. This is like, I think Information Security Exhibit 2, I believe, if my memory serves me, takes up almost 2 pages in itself. Cisco was very thorough, and I think they had some good guidance from somebody else who was very thorough. I won't say who. So this is an example. They're wanting to know, is it secure? And it's not going back. There we go. What are the protections that you have in place? So Cisco says that this information security exhibit applies to the extent that Cisco processes or has access to protected data. And then it just goes on to talk about how they actually do the security at Cisco. The next one is supplemental info compliance. This basically just says, yes, we will be compliant with the supplemental information. We will provide you with the supplemental information. And then later on, we're going to look at how they provided that supplemental information. Again, we're talking.
Right. And so here, thank you, Monica, is one of the first examples of the overlap in these in the parts of the agreement. So the it references the supplemental information, which is the information that you have to post to the public. So you'll see this kind of repeat as we go through here.
So contractor training, EDLA 2D does state that any vendor that you work with has to make sure that that their employees who have access to the protected data will have training about protecting the data and what needs to be done in order to be what's the word? And compliance with FERPA and COPA and EDLA 2D.
Can I just make one point here, because I know that we've all seen the statewide proposed or model data security and confidentiality agreement. And this oversight of subcontractors is the first time that we'll see a deviation from what EDLA and Part 121 of the regs require. Here, we're saying that the contractor is responsible for the oversight of subcontractors. In the statewide model from the CPO's office, you'll see that the districts are required to approve all subcontractors of a vendor. And so then you can see sort of the deviation from what's required in the law versus what they're modeling from the CPO's office.
Are you referring to this slide right here, Michelle, where it says Cisco will utilize or will not?
I'm referring to what we've all seen in play as the model from the CPO's office. The Chief Privacy Officer has put out a data share and confidentiality agreement model. And I just wanted to make the point that the law only requires that the contractor have oversight of the subcontractor, including the training portion. So I'm sorry to break in, but I just wanted to show sort of where there's a bit of a deviation. And again, this is where we go back to reasonable minds can differ as to the interpretation of the law and the regs.
And just also to be clear, as of this recording, the middle of May, nothing official or formal has come out from the state education department on having any kind of statewide data privacy and sharing agreement. So it's really important to know that nothing official has come out from the department. So at this point, we're going by our best understanding of the law and regulations.
Thank you. So on that note, subcontractor training, the regulations asked, does the plan specify how the vendor, the sub-assignees, which would be the subcontractors, who are going to have access to PAI will receive training? And in this case, Cisco said, yes, we will utilize subcontractors, and we will make sure that they have training in accordance with the written agreement described in the BOCES supplemental information below. And then this says, does the plan specify if the contractor uses subcontractors and how, again, redundancy. And then the next bullet point asks about a cyber incident plan. Does the plan specify how the contractor will manage data security and privacy incidents, identify breaches and unauthorized disclosures, and promptly notify the agency? That one's pretty self-explanatory. You know, if you have any sort of a breach, what are you going to do with it, Cisco? And Cisco replies that they will absolutely promptly notify BOCES no more than 7 calendar days after they are made aware of it. And they're going to provide that notification to the BOCES by contacting the general counsel. In this case, for CRB, it's going to be Michelle Jones. Now, for a district, you might have them contact the DPO. Okay, data transfer and disposal. This talks about whether Cisco is going to remove what they're going to do when they are done with a contract. What are they going to do with your data? And they, as you can see, they answer that they're going to return it, delete it, or destruction, whatever works for the BOCES. And then last but not least, for the data security and privacy plan, does the plan include a signed copy of the district parent bills and rights for data security and data privacy and security? This is so important. And Michelle, I did want to point this out because I've had some districts that are struggling with this. You, for CRB, you've put the signature at the bottom of every piece of paper, like the supplemental information and the Parents' Bill of Rights. Can you talk a little bit why you did that?
I really break my data security and confidentiality agreement into the three pieces that we're discussing right now. And so this second component, the Parent Bill of Rights, is something that the vendor agrees to abide by, but all of the terms and conditions really should have a signature indicating approval by the vendor, acceptance of the terms and conditions. So I know that I'm happy to share the Cisco data security and confidentiality agreement with you, and also the model that we use for the data security and confidentiality agreement. And yes, you'll see each section has a signature line for the vendor to sign, indicating agreement to the terms and conditions.
So that's a great idea. And Michelle's very thorough. And as a district, you don't want to do that. If you don't want to do that, please make sure that the Parents' Bill of Rights has the signature field on that page at least. Okay.
Lorraine, you had a couple questions before we move on. Do you want to ask those?
Sure. Thanks, Mike. So the one piece about the contractor saying that they will provide training for their staff and for any subcontractors, do they need to specify what that looks like, or when it's done, or how long it is, or if they just say it is that sufficient? So maybe Michelle has the answer for that.
Yep, sure, Lori. And so I do look at what they say their training is. And if they say something like we train our staff and we make sure our subcontractors train our staff, I don't think that that's sufficient. And so I push them a little bit harder. And I say, when do you train your staff? Well, we train them, upon hire, and we train them annually, and we train them after an event happens where we have to improve our practices. And so I like to see specifically how the contractor trains its employees. And I also like to see an affirmative statement that they've reviewed the training plan of their subcontractor and can affirmatively state that it complies with Ed Law 2D in Part 121 of the.
Thanks, Michelle. And my second question was about the data breach. So I saw in this contract, it was within 7 days, no later than 7 days, that Cisco would let you know, right? That it would go directly to you, Michelle. But would that be a period, or would we want something? Should all of us look at 7 days as like that's the magic number, perhaps, for us to be notified?
Lori, that is the magic number, and that is what is allowed by the statute and the regulation. So I picked 7 because it is reflected in Part 121 of the regs as the necessary notification time. And again, this is another point where what the regs and law require deviates a little bit from what the model from the chief privacy officer is putting forward, because in her model, it's a 3-day notification period from the date of the breach. That's more it's more rigorous than what is required under the law and the regs. So 7 does come right out of the regs. Mm-hmm.
Perfect. Thank you.
We like to follow the law. Okay, let's move on. So we are at supplemental information. Now this one, we've been talking about this since 2014. So this one we should be able to fly right through. This is our 6 parts that have to be posted out onto our website in one shape or another. I'm recommending, of course, that we put them in the RIC1 inventory tool because it's the easiest way, and we won't go into that because we've already done that presentation. But this is what has to be posted for your parents. This is what the transparency is all about. So the vendor has to let you know what the exclusive purpose of which the data is going to be used for. And I don't think Michelle would let them get away with, well, we're just going to use it to make the software work. Is that going to work, Michelle?
No, it's not. And so I need them to very specifically tell me how they're going to use the data. And I want to make sure that they don't insert terms like, we're going to use your data and de-identify it and use it for commercial and marketing purposes. For example, that's what Zern, you might be familiar with that vendor, is saying right now. So I want to make sure that the vendor is going to only use our protected data for legitimate purposes that further the educational needs of Capital Region BOCES or HFM BOCES and our school district clients.
Michelle, you can agree with me on this or not. I've looked at some privacy policies, and one of the first things it says is we will use your data for commercial and marketing purposes. Is that a red flag?
Yes, absolutely. Any vendor that wants to use protected data and turn it into anonymized or de-identified data is, in my opinion, using that data for commercial purposes with the specific intent of marketing to school districts and then reaching down to our captive audiences, our students and our staff. This is my conservative view of the law, which very specifically prohibits a vendor from using protected data for commercial purposes. Again, reasonable minds can differ, and there are different opinions out there.
Thank you. Oversight of subcontractors, I think we've already talked about this, but again, Cisco will ensure that subcontractors, assignees, and other authorized agents abide by the provisions of this agreement. It's their responsibility. Contract duration and data disposal. What's going to happen to the data when the contract expires? Cisco says that they will securely delete or otherwise destroy any of the PII remaining in possession of Cisco. They're very specific about that. Data accuracy and correction practices. If there's something wrong that a parent sees on the app that their student is using, how do they fix it? They need to have a way, parents and students need to have a way, in turn, then districts to the vendor has to have a way of how they're going to fix any data that's wrong. And here Cisco says, great, contact the student's district of residence regarding the procedures for requesting amendments. So what does that really mean? Probably contact your BOCES and have them fix it in your student information system. Security protections and data location. Now they have to talk about where they're going to keep the data and how they're going to protect it where it is. And encryption practices applied.
Can we go back to location and protection? So I think this is something that's important because some people view this as, oh, you have to say where the data is, then that means it has to be in the United States. That's not true. It just has, the vendor just has to tell you where it is. It could be anywhere, but they just have to tell you where. And it's important in terms of the security protection procedures that there is a little bit of detail in there. You know, like this idea that aligned with industry best practice and practices and standards, that's important. So, and see how they give some examples there too. It includes, but isn't limited to, disk encryption, file encryption, firewalls, password protection. So it's not enough to say we protect your data. They have to give a little bit more detail. So thank you. Sorry.
I also wanted to note on that because this is what we're putting out to the public. You also are allowed to, if there's anything that's going to compromise your network, so this is where your tech directors are going to come in. If your contract in any way is going to compromise your network, you can redact that kind of information, as well as pricing. If you are choosing just to put your contract out on the web, I don't know that anybody is doing that, but if a district does choose to do that, they can redact that kind of information, the law states. Okay, encryption practices applied. So this basically means how is the data going to be protected while it's at motion and at rest. That's the law, that it has to be protected, even if it's not going anywhere, if it's just sitting in a database. How are you protecting it? And in this case, Cisco's protecting it using very specific protections that are by the Department of Health and according to HIPAA. Did I say that right? Is that according to HIPAA, Michelle?
Yep, you got it. Good job.
Thank you. All right, so we're on page 8. How are we doing?
Go to page 8. Let's pause for a second. I think we're doing okay on time.
Okay.
Any questions on what we've talked about so far? Okay, press on. Oh, sorry.
Mike, just sorry, I couldn't get to my mute button. So just to be clear, the page 7, Monica, in that piece, and I think it's a Michelle, this has to be completed and posted, yes, on our website?
Absolutely.
Okay.
Yep. I think you were at our training, Lorraine, for the inventory tool. I can show you later. We'll be going over that again on next Wednesday's training.
Thanks, Monica.
Okay, so page 8. This is where the redundancy really comes into play a lot, but there's some stuff on here that is not covered on the other 2 sections that's important. So we're going to take a look at additional statutory and regulatory obligations. Includes language that requires the vendor to provide notice of breaches and unauthorized disclosures of protected data in accordance with the Commissioner's regulations no more than 7 days after discovery. So somewhere in your contract, if it wasn't covered before, you must make sure that you have language in there of what's going to happen if there's a breach. And it should be no more than 7 days after the discovery. So that definitely is best practice and should be in your contract. And I showed this before, Cisco for sure has that in there. The NIST CSF safeguards. This states that vendor will adopt technology, safeguards, and practices that align with the NIST cybersecurity framework. That might be difficult to get your vendors to actually say NIST cybersecurity framework, because to be honest with you, most vendors use something that's probably even more stronger than the NIST cybersecurity framework. And in this case, I believe Cisco is going to be one of them. They say such processes and procedures shall be designed to provide appropriate security to protect data, to protect protected data, and it will not be any less strict than the information security requirements set forth in this information security agreement. So, but that definitely has to be in your contract somewhere, that they will be at least NIST CSF compliant.
Can we pause there for a second? So Michelle, if you've negotiated a bunch of these, when vendors give you a hard time about using the specific language NIST cybersecurity framework, where does it go from there with you?
It's a back and forth. And so in this case, Cisco was reluctant just to tie themselves to the NIST cybersecurity framework because it's not a certification, it's not a security certification, it's just guidance. And so in this case, it was easy to say, look, you have ISE certification, and so thus you're definitely compliant with the NIST cybersecurity framework. But you do have to ask for more information. If they say they don't want to put that they align with NIST cybersecurity framework, you have to ask the question why. And if it's not there, you have to make sure there's some equivalent or above certification there.
Yeah, that's great. I mean, ask why. Are you better than NIST? Then what is it that you have? Okay. Next we have compliancy with agency policy and Ed Law 2D.
This one, I'll take this one. This is just, they have to stipulate in the agreement or indicate that they will conform to the Education Law 2D, the regulations of Part 121, and also to the policy of the agency with whom they're contracting. So this is just them saying that they will.
Limit access to PII. That's another redundant, easy one. They're just going to say they have to put it in writing that they're not going to let anybody have access to the PII unless it's needed to in order to fulfill one of their obligations. This is huge. This is what EdLaw TD is all about. Vendor will not use the education records for any purpose other than explicitly authorized in the contract.
And Michelle mentioned this a little bit before about this. This is where the de-identified data falls in, right, Michelle?
Yes, Mike.
So, like Michelle said, reasonable minds differ on the extent to which a vendor can use what they would consider de-identified data for their own purposes. So to, improve the performance of their product or whatever. So we've taken a pretty conservative approach at Cap Region BOCES that de-identified data is still PII, and Michelle is negotiating with vendors to have that not be allowable. And Lorraine, you have a question about that?
When we're talking about de-identified data, we should be concerned, according to this slide, only if it's PII that would be de-identified, right? If there's any other information, and maybe Michelle can speak to this, I don't know what if
right.
there. Yeah, go ahead, Michelle.
All right, Lori. So, if we were to give this vendor de-identified, anonymized data, we do have the ability to anonymize our data and give it to the vendor. And if we gave it to the vendor, it's not protected data because it's de-identified data, then they could use that for whatever they wanted to do, commercial purposes or marketing, whatever they needed to do with our de-identified data that we gave to them. But when you're talking about student protected data under EdLaw 2D, the definition of protected data is extremely broad. It doesn't have the carve outs for directory information that the federal privacy standards have. And so practically everything out there when it comes to a student record is protected data. Not so much with APPR information, that's pretty straightforward. But if a vendor were to take the protected data and anonymize it or de-identify it and then use it for commercial purposes, it's my interpretation of the law that this is prohibited. Because they start with the protected data, they manipulate that information, and then they use it for commercial purposes. Does that help at all, Lori?
Yes, thanks so much, Michelle.
This is one of those times where, like Michelle said, reasonable minds differ. So this is something that you're going to want to make sure that is clear with your own school district's attorney.
Okay, vendor will not disclose PII to any other person, except a person authorized by the vendor to carry out the contract. Again, we're doing redundancy here, that they will not give any PII to any other party unless they are representative of Cisco or its immediate affiliates. Safeguard the PII in custody, that the vendor will maintain reasonable administrative, technical, and physical safeguards to protect the security, confidentiality, integrity of PII student information. So this means that they're going to do their very best to protect your students' data. And this is right from that they just took it right from the regulations and they put it right into their contract that they would maintain. Encryption practices applied. They did talk about that they will be using encryption by firewalls and or password protection. All of this must be in place when the data is stored or transferred. So,
yeah, and you can see there, that's the same language that was earlier in the presentation. So you can see again, kind of the redundancy here, but again, it doesn't hurt to make sure that everything is included.
They couldn't fit everything on 6 and 7. They couldn't all fit it on page 8. But these are the main things here. But then they left a couple of things out off of page 8. Prohibitions on commercial use. And This is a little bit of what Michelle was just talking about. That Cisco agrees that they're not going to use the PII for any other purpose, for any kind of commercial use. They're not going to sell it. They're not going to use it to try to fix their product. You know, that they have to say that they're not going to. And then last but not least, oversight of subcontractors. And I think we've talked this twice already. That anybody that works for Cisco or that Cisco subcontracts with, I should say, they will be they will be bound by the agreement that Cisco has with your district under Section 2D of New York State Education Law. Okay. That's it. How'd we do on time? Good?
Spectacularly. So that was a lot of information in a short amount of time. So maybe if we take a second and let's put Lorraine on the spot and Michelle and Elliot. If you were going to sort of identify what were the big ideas for you that came out of this, I'd be curious to know that. And then Lorraine, you also said you had a question.
Let's take Lorraine's question first.
Okay, I was just sorry, I was still on mute. I'm talking. I was going to say, do you want the question first or do you want me to? So my question is on page 6 at the very top of this, it says, you know, select a district software platform and work with colleagues to populate information from the related contract into the third-party contracts checklist. So
Yes.
I know Michelle knows my thinking on this because she's part of a statewide listserv that we both participate in. And I mentioned in a comment to that listserv, which is the New York State Personnel Administrators, that doing this process, going through those contracts is not a simple process. And I think the recommendation would be, and Mike, this might go back to your consult your local attorney response, but I am hesitant to either say that I'm going to look at those contracts or assign that work to somebody in my organization since I am not an attorney. So could we speak to that? I'm worried that districts or other BOCES might say, oh, sure, we'll just read through there and yep, that looks good and that looks good, but not really having that legal training to be meticulous about the language in the contract.
Who wants that one? I totally agree with you. I totally agree with you, Lorraine.
I think this is, and again, like the purpose of this, like we said at the beginning, was not to turn anyone watching this into an attorney, but there's no reason that somebody in the district can't take a first look at this. Or maybe if you get into negotiating an agreement with a vendor, or you want to engage with a vendor doesn't have a contract with a BOCES or isn't on a statewide consortium, this is a place to start. So even if it were to be just giving the vendor either the language in that WebEx agreement that we'll make available to you, or give them this checklist and say, listen, these are the things that have to be in there in order for us to enter into a contract with you. And then let the vendor do work on their end. And then ultimately, I think it would be my recommendation, and I'm guessing it's Michelle's without putting words in her mouth, that you still are going to want to have this reviewed by your attorney.
Yeah, I would agree. I think those are great plan or great ideas that Mike has to do that. And, you know, we don't all have a Michelle Jones in our back pocket. So, and I've heard that from districts before. They've said, Monica, you know, we don't have an attorney on call. You know, we have one, but it's like if something bad happens. But I still think that if you, like Mike said, if you put this, when you start doing a couple of these contracts, you'll be more comfortable with the language. And if you do like a preliminary contract using the tools that we have, this checklist, and the agreement that Michelle has put forward, you get most of that filled out, but I would still feel comfortable then sending it to my attorney and having them check through it. You know, attorneys usually charge that are not on retainer by the hour, right? So, you know, I think if you put it all together and then had your attorney spend an hour looking at it, that would be helpful. But I agree with you, Lorraine. We are not attorneys. That's why I've got Michelle on speed dial because I don't ever want to answer that.
Yeah. Thanks, Monica. And Mike, I think you stated it very well. But the other thing is you can standardize on a template that you use for your vendors every time. So your approach is uniform. You can say these are the terms and conditions that you have to agree to. And then the vendor will either give a thumbs up or a thumbs down. They'll sign it or they won't. But once you become normed to what terms and conditions work for your BOCES that you require from all of your vendors, it might become an easier process, one that your attorney, your outside counsel agrees is the correct template and the correct process for your district. And then, it's a matter of communicating with the vendor. And most of the time you have relationships with your vendors that would make it easy for you to have this conversation. So long as you're clear in your understanding of what works for your district or your BOCES.
Well, the good thing is all the vendors in New York are aware of this now. I get invited to presentations that are geared towards vendors on how to prepare for EdLaw 2D. So they all are starting to get in the swing of knowing what they're going to have to provide for districts. So I think I could envision seeing more templates being passed around.
So as we kind of wrap up here, I am curious to know from Lorraine, Michelle, and Elliot, what are some of your biggest takeaways from this? Anything new that you learned or anything that you think, wow, I really need to remember?
I'll start for my team. So one of the things that really helped me was that confirmation today during this conversation that just because a software program is EdLaw 2D and somebody has signed it somewhere in New York State or somewhere in the world, mostly New York State, doesn't mean that we can just arbitrarily use that software and we're still under that protection of that agreement with someone else. So that was very helpful. I've had staff members say to me, well, it's on the Erie One list, or it's on this other list, and I was like, well, but we don't buy it from them, or we haven't bought it from them. So that was extremely helpful just to have confirmation about that. There are many other things, but I'll just stop for a moment and see if Michelle Husick or Elliot have comments about today's information.
Hi, it's Michelle. I agree. That was one of the things that I took away from that too. Having that clarification was very helpful. And I also like the idea of a template that we could do for just a standard. Then maybe have an attorney look that over as a template and then just kind of tweak it from there per vendor. I like that idea too. So definitely willing to work on that. But this was great. That's always helpful. The more information we can have, the better.
And to your point on that, Michelle, I think the template's a good idea because that puts the work on the vendor. Let them do their work and agree to your terms. So yeah,
Exactly.
good one.
Yeah. Thank you.
No, and I personally like the layout of the presentation, how it broke down, the pages 6, 7, and 8. A thing that I usually always forget about is the subcontractors piece. And making sure that, the contractors, whatever third party they're using, are included in that is something that I personally often forget about, and it's always good to circle back. But no, I really liked how this presentation was laid out.
All right, any parting shots, Michelle or Monica?
It's always a pleasure working with HFM, so I was glad to know that they were our target audience for this presentation. So Lori and your team, it's great to see you all and be part of this conversation. So thanks for letting me join today.
We're thrilled, Michelle. Thank you. I've always felt very confident in information and advice you've given to us. So thank you for putting this together. When I said help, I think we need more information. So thank you very much.
Yep.
And I'll just ditto what Michelle said, Lori. I'm so thrilled that you were the one on the other side of the camera.
All right, well, thank you everyone for participating. And for those of you who are watching this recorded later, hopefully it's helpful. And I know as Monica uses this in her trainings that there will be ample opportunities for folks to ask additional questions. And certainly, Monica, if you want to go to your last slide there, if you do have specific questions that you think Monica might be able to help or find answers to, you can hit her up at dsp@neric.org. And again, thank you for your time, and we certainly hope that this was helpful.
Thanks, Mike.